There's been a lot in the news of late about CPPA and the fines that they have been levying on companies. The CPPA is the California Privacy Protection Agency. They are tasked with enforcing the California Consumer Privacy Act, which is a privacy law available for all California residents. What are these actions taken by the CPPA? Let's talk about that a little today and figure out how we can comply with the CCPA and the other privacy laws that are currently live. Which were companies that were recently impacted by the California Consumer Privacy Act litigations? Back in August 2022, it was Sephora. More recently, Honda Motors and Todd Snyder have been in the news for being levied fines by the CPPA. What are some common issues between these cases? To start with, proper notice was not provided when customer information was shared with their partners. Now, California Consumer Privacy Act considers the sale of data to include non-monetary sharing as well. This was not disclosed in the privacy notice. Opting out of cookies was complicated. Something as simple as a reject all button was not provided. The process of opting out or exercising privacy rights was made very difficult. More personal information was requested. Photo identities were requested. The process of accepting authorized agent requests was not provided. When it came to third-party risk, finally, the ability and timeliness to cure the violations was not met within the sufficient time period of 30 days. What are some fallouts of these litigations? There's a financial impact, the customer impact, and an employee impact. Eventually, there will also be a vendor-based impact. The fines themselves are a significant financial impact. Along with that come your legal and litigation fees. From a customer standpoint, they lose trust. That basically means that it could have an impact on your revenue and your sales. This then has the third impact on the employees. The employees lose a sense of pride because the brand is in the news for the wrong reasons. Productivity is impacted because people are not clear if what they're doing isn't compliant. Will they be able to complete the tasks required without violations? All of a sudden, things could come to a standstill. Everything has to go through the privacy office. Everything has to go through legal review. If the processes are not already in place, this slows things down tremendously, which is why I say that's the second level impact on productivity. The fourth and the final impact would be vendors. Vendors would still want to work with you, but now they know that the legal and contractual processes are going to become more complicated, given that there are going to be more hoops to jump through. And if the teams are not ready and prepared for these new changes, there will be inevitable delays in closing of contracts as well. Why is it so hard to cure the violations within the 30 days time stipulated by these laws? When it comes to cookie compliance, business overpowers the compliance and legal teams. Why does that happen? The business is on the hook to make sure that they get the maximum bang for their buck. Every activity made by the customer is tracked. Every page browsing, every addition to the cart, every single action needs to be maximized. This is typically done through tags and cookies. Hence, business always pushes to ensure they can have the maximum amount of tags and cookies on the website. So in some cases, compliance takes a backseat. The second reason is an inability to understand the technical implications around dropping cookies. Tool configurations also suffer. Setting up the banner, if it's not done correctly and appropriately, you're not collecting consent before you're dropping the cookies and the tags. Sometimes, even if you are collecting consent, the tags and the cookies are not listening to the user preferences, and hence the tags and cookies are not compliant. The final aspect of cookie compliance is cookie governance. Having a set cadence of cookie governance, whether it is 1 month, 2 months, 3 months, the process of scanning the website to look for new cookies and to ensure that the cookies are still compliant with the consent preferences established by the visitor. This aspect requires constant monitoring. A cadence of even up to 3 months is essential. Most consent management platforms release new versions of the software. More partnerships with different marketing agencies and ad agencies causes new cookies to be dropped. All of these have to be put together in a cookie governance cadence, which ensures that you have constant compliance. Legal, in most cases, is not aware of the data sharing practices of the business. Why is that? Because there isn't an inventory or a data map of all your systems, processes, and vendors. So legal is not aware of what data is being collected, who it's being shared with, why it's being collected, where it is stored, how long is it stored. These aspects make the notice practically impossible to keep up to date. If the notice is outdated, then that is one of the first aspects of privacy that has been violated. Not providing adequate notice at and before the point of collection is a breach against every single privacy law. The data retention schedule isn't always enforced. This means data is being stored for longer than it needs to be. This leads to exposure to data breaches. The lack of a privacy program also means that training and awareness is not part of the regime within the organization. All of these eventually hurt the cause of privacy within the organization. When it comes to third-party risk management, cybersecurity or infosecurity procurement teams are more familiar with these processes. Cybersecurity has been around for a little longer, and hence departments, divisions, businesses are aware that this needs to be done. There are standards and templates in the market that allow vendors to provide their SOC 2 report or ISO 27001. So cybersecurity and infosecurity actually gets covered, but privacy is still maturing in these standards. There are standards out there, but they've not been completely adopted by vendors. It's hard unless the privacy team partners with the cybersecurity team and the procurement teams to bring in privacy risk evaluation as a prerequisite for the signing of any contract. Without any risk evaluation, there is no hope for a data protection agreement to be included as part of the contractual terms. How do we solve some of these problems? I would start by looking at the public aspect first. Your cookie banner. Do you even have one? Does it have a simple reject all button to make it easy to opt out of all non-essential cookies? Is your tag manager listening to the consent preferences set by the user? If scripts are being called directly on the page, make sure that they're consent aware. Second, I would look at the notice. Are the personal data elements being captured, shared in that notice? Next, I would look inward. Begin by creating an inventory of your systems, processes, and vendors. Start with your customer's journey. Look at the inbound flows. How do you collect information? How does that data flow within the systems within the organization? How does it flow back out to the customer? Look at your marketing initiatives. Look at your customer care services. Look at your outlet channels. There are ways to be able to build that list, and it becomes an organically growing list. Streamline your data subject request fulfillment process. Invest in a privacy governance platform that will allow you to be able to record all these requests, audit them, and respond in a timely fashion. Partner with your cybersecurity, infosecurity, and procurement teams to ensure that privacy risk evaluation is happening with every single vendor. Start with new vendors. Then on every renewal of certain vendors that are already doing business with you, include the privacy risk evaluation. So it gives you the data protection agreements that need to accompany your vendor contracts as well. The final aspect is cookie governance. Get into a cadence of running scans on your website, whether it's once a month, once in 3 months. Get a log of all the cookies being dropped. Identify cookies that have not been categorized or classified yet. Run scans from different geolocations with the GPC signal on, GPC signal off. Ensure that cookie consent is being honored in every one of those situations. If not, work with the tag management team, work with the website or the customer experience teams to ensure that any anomalies and discrepancies are immediately fixed. Then run scans again to make sure that things are looking good. Keep that discipline up to ensure that you have constant compliance when it comes to cookie consent. Privacy is now table stakes across all industries. Privacy is not a single team's effort. It takes an organization to become privacy mature and ensure privacy compliance across all aspects of the business. This takes time. Through assessments, more than training and awareness, the organization matures and becomes more privacy aware. To cite an example, one of our customers, a retailer, we worked with them for over 2 years and covered 400 plus application systems assets. We evaluated all of them and came up with a clear risk outline that enabled us to identify all associated processes. This led to significant visibility into the privacy posture and the risk posture of the organization towards privacy. Naturally, the adaptation of the notice became easy. Cookie compliance was front and center. Governance was taking place on a monthly basis. These actions enabled business, technology, procurement, security teams to be so much more aware of every single action being taken by business. The teams became proactive in reaching out to the privacy office and requesting assessments to be done, even on vendors that have been previously assessed, only because they have now decided to share additional information with the vendor. This level of awareness did not come overnight. It took 2.5 years and a whole lot of assessments. But it also took a lot of leadership push to make privacy a priority. Starting now will ensure your organization has enough time to enforce a robust privacy program. You can then make privacy a differentiator in your operations. Finally, it leads to peace of mind.